landlords want this a little bit sooner. But this is a form that is to be completed by the tenant first and then held by the landlord. I believe that it's part of the question that was put on the table. What happens to the monies? The money sits in the landlord's bank account until such time where the tenant vacates the property, and at that point in time, the landlord will have 30 days to return that money to the tenant. Make sense? All right, away from this one. Oh, great, we're in paragraph 3 of 16-page documents, and I got 25 minutes. So we're gonna rock and roll. All right, there's a reason why I printed this document for you. If you have any issues locating, please refer to those documents. I will want everyone in this room to read at least once, if you haven't already, the entire contents of all these documents so that you will be familiar with it. It would be great if you could remember where all of these pieces of information are so that when you sit in front of a client, you can explain. Remember, this document is derived from, and it is consistent with the property code that I'm going to be emailing to you. There are some choices here that need to be made, and frequently, as you can see in this document, speaks to the landlord's wishes for his or her or their expectations. Okay, but there are some choices nevertheless that need to be made, and these choices do mean something. So it is important. I don't want to read the document to you. I don't want to insult your intelligence. That's why I'm asking you that you do take the time to go ahead and read them. If anything stands out from here that appears to be a landmine, I will point it out to you as we move through this. Remember, when something is underlined here in the contract, it's because it's very important. If you move to line B of paragraph 4 and you check 1 or 2, it will mean different things. And so this talks about when the property will renew, and then when the triggers take place. This has to do more with proration than anything else. What I explained to you earlier is the common standard for our area. But do make sure that you review these documents as you are going through the process. Remember that on the top of each page there is a line here for the address, and that is important. In zip forms, when you put the address of the property on the first field, it would automatically populate the first line of every page. So it's very useful. The amount of the rent, of course, will have to be according to whatever property is that your client's interested in leasing. And then on paragraph 5A, you will see that the first full month rent is payable not later than, and that is typically the day that the lease is supposed to get started. Here in this office, we don't receive anything but cashier's checks and money orders. We do not take personal checks or cash. However, from that point forward, it is up to the landlord as to what they will accept. Most landlords will accept electronic payments, money orders, cashier's checks, but that is one of the landlord's wishes. So they typically will have to identify the means. And then it begins to state when the rent is due. And this, you can check the box the first day of each month during the lease, or if there is another date, then it should be inserted in there. Then the proration of the rent, this is like in my example of February 15, this is well, you will have, let's say in this case will be on or before March 1st, the tenant will pay the landlord, you will prorate the month of February, divide the monthly rent by 28 for the month of February, and then you will multiply it by 15. The first and the last day do count. So here is where you would do the multiplication of, you know, in my case, if I wanted to do the rent of $3,000, I will simply do $3,000 divided by 28, and then I will multiply 107.14 by 15 days, and I will come up with 1607 for the 15 days of February. That is what will go into that field right here. That make sense? Okay. Then the placement of payment, or place of payment would be, who would decide that? The landlord, right? All right. The method of payment, again, is defined by the landlord and who they believe or what they believe it's most appropriate to them. But do please read the paragraphs in their entirety because they do mean things that are important. Rent increases. This is another field that is significant because a lot of people will ask you. There will be no rent increases through the primary term. The landlord may increase the rent that will be paid during any month-to-month renewals, and then they will have to provide written notice to the tenant on at least 30 days in advance. So at the conclusion of the rent, if the landlord has any intentions of raising the rent, they will have to notify the tenant in writing as to what the increase will be, if they're going to permit for the property to go month to month. Late charges, now this is up to the landlord again to decide what day actually is the final date by which they would allow payment for the rent. In my case, I allowed my tenants maximum of 5 days. Rent is due on the 1st, however, but I can still receive the payment by the 5th without any penalty. As you move forward, you will see that there are stipulations to that. If they are late on their payment, then we'll charge $50 for late, and then 5 additional dollars per day following that. If there is a bounce check, a return payment is 35 days, and if you look at the property code, you will see, and I believe it is also written here, that it is a violation of the law, penal code law, which is a criminal offense for someone to give false checks or checks that bounce to the landlord. That is significant. They can be prosecuted for fraud. Okay, then there is a pet addendum that needs to be filled out in case that you have a pet that is going to be residing on the property. And the pet agreement is 2 pages. And don't ask me why they want to know what the name of the dog is or the cat will be, but somehow they consider it significant. You see it here. And there's room for 2, as if it wasn't difficult enough to find a house that would allow dogs or cats. Here they give you space for 2, but there are people that have more than 2 pets, and they have to actually include, interestingly enough, the names of your goldfish and, and birds, as if birds would ever recognize their names, or rodents for that matter. So you have to fill an application for any one of these types of pets that are included in the description. Mammals, reptile, birds, fish, rodents, or insects.
Are you in the lease agreement or a separate agreement?
I'm sorry, I'm in the pet agreement.
Did you use a copy of that?
No, is it included on there? No, I didn't. No, I'm sorry. Yeah, so sorry for making you flip through nothing, but it's the pet agreement. It's in zip forms, and it's a two-page document that needs to be completed and submitted with at the time of application.
Only if they have a pet. Only if they have a pet.
Yes, only if they have a pet, only if they accept a pet. All right, so now there are repercussions for violation of this paragraph. In my case, I do $100 plus an additional $10 per day for people who violate this particular paragraph, meaning that if they do not accept pets and they do not have a pet application and you do find them to be residing with a pet, this goes in motion. The security deposit, then it's for the purpose that I described. And then there is a correlation to paragraph 92-102 of the property code that hopefully by then you will have memorized or at least available somewhere that you can go to and refer to it. All right. Then you have a paragraph for interest and refunds. I highlighted here that the property code provides that a tenant may not withhold payment or any portion of the last month's rent on the grounds that the security deposit is security for unpaid rent. Okay, so if you refer to the property code, it explains in details exactly what each one of these violations mean. Read paragraph 3, for instance. The property code does not obligate a landlord to return or account for the security deposit until the tenant surrenders the property and gives the landlord a written statement of the tenant's forwarding address, after which the landlord has 30 days into which account. If the vacating tenant does not provide an address, forwarding address, for 15 days after they vacate, then the landlord will have 30 days from the time that they learn what the forwarding address is, not from the day they vacate. Surrendering means, as defined in paragraph 16 of this lease, and that is mean vacating the property and leaving it in suitable condition. This website that I just referred you to is actually the Texas Legislature's website, where you can find the most updated version of the Texas Property Code. Here are the deductions that the landlord may actually deduct charges from. It's for not just damages for properties, but unpaid utilities, unpaid pet charges, attorney's fees, and damages caused to the property from a variety of reasons. If the deductions exceed the security deposit, then the landlord will have, within 10 days, may ask for demand in written form. And all I have to say is good luck with that. But just because if the landlord finds that, for instance, the appliances are damaged, meaning the stove, they find glass breakage, they find that the carpet is ruined, paint needs to be addressed, and clearly it exceeds the amount of the deposit, the landlord may go after the tenant by notifying in writing first and then demanding that they compensate the landlord for the excess amount that was originally given in the form of deposit. In most cases, the landlords will not pay for any utilities, but in the area you will see that there are properties that are fully furnished and where tenants actually receive paid utilities. I have none because in my properties I do not offer the opportunity to receive utilities, but there are furnished properties. Yes, ma'am.
Paul dealing with a client right now that someone was in the property for a year and they left a squeegee for the shower to be cleaned, so it was a glass shower. Well, it's destroyed because they never did it, so there's so many hard water stains you can't even see through the glass shower. And they were trying to decide if that was something that they could charge them for replacing the shower.
Well,
That's considered normal wear and tear.
it is considered normal wear and tear, but if it was expressed in the lease to begin with, that they wanted them to use the squeegee and maintain the glass in pristine condition, that should have been in written form from the very beginning. If it wasn't, I would say at least go through the motions of having someone professionally clean the glass, and they may deduct that from the deposit because it in the property condition inventory condition form probably was not identified as a problem area. The landlord has the expectation of receiving the property in the same condition that they gave it to the tenant. So I think may not be just cause to pay for the replacement of the shower glass, but it could probably be justified to say it's going to cost me $100 to have professional cleaning for doing that. All right, then the occupants need to be named on the lease, and it has to include the ages and the names of all the occupants. So then there are specifications about phone numbers and emails that the tenants must properly inform the landlord of any changes in tenants. That's to keep the lease current. It makes them aware of HOA rules, things that are prohibited in the on the premises. Be sure to read all of that. Stipulations as to how many days a guest may be allowed to remain on the property unless written permission is given. Parking rules, typically the number of vehicles that are allowed to be maintained on the property. You have condos that only would allow 2 or even townhouses because excessive parking. And so be sure that you understand that the property allows the number of vehicles that you're going to put in there. Again, these fields are most likely to be completed by the landlord than the tenant. If the landlord does not provide documentation in here, then you may only set the expectation correctly that the landlord may change it in the last minute. Here are trip charges, a charge that the landlord typically expresses. On the last 30 days, I have on my lease that they have to give us authorization to place a lockbox. The tenant must give us permission to place a lockbox with a key, otherwise we become liable. Remember that it's easier to do this application at the very beginning where you still have a great relationship with the tenant, so you have them complete that authorization in the very beginning, giving you authorization to complete. And then remind them at the very end, when you're about to complete, to put the lockbox, that you do have their authorization. And if they do not allow the authorization, it could cost them, in my case, 1 month rent for not allowing us to market the property for the last 30 days of the lease. And if they do not allow access into the property, I charge them $50 per instance for not allowing me to access to the property within the last 30 days to show the property. The move-in condition, typically the landlord offers it as is. And then in this case, I have 10 days, as I mentioned before, for completion of the property condition and inventory form, property inventory and condition form. The move-out condition is specified on the contract. And then there is a stipulation as to, there is a definitions that are occupied, also narrated on the property code. And then it describes what happens to items that are left on the property. Yard maintenance is an important item that needs to be addressed. Who is going to be maintaining the yard? If the tenant is to maintain the yard, even there is a stipulation as to when the property may be watered. In the Woodlands, sometimes there are restrictions as to how many days a tenant may water. And sometimes what it's put on here as an explanation is according to township restriction rules. Okay? Sometimes they do have extreme watering conditions, and they only allow you to water 1 day a week. So the lease cannot be in violation of the deed restrictions. Okay, so here is landlord's choices as to who will maintain the yard. And if there is a contractor involved, here there is a name of a contractor and sometimes a place to contact. If there is a pool on the property, there is also addenda pertaining to the pool maintenance, and you need to refer to the addenda for additional instructions as to who's responsible for what.
Is that a separate form?
Yes, there is a separate form.
Is it promulgated?
There is a promulgation on that particular form. Let's see if I included it. It may not be in your packet because I didn't consider it relevant to what we're trying to do today, but it is a promulgated form, and it is form number TAR 2010, and it addresses all of those items. Who's responsible for what, insurance and all that. Okay. Okay, then there are prohibitions as to, additional alarms. Locks need to be replaced by the landlord per property code within the first week of arrival. So that means that the landlord has to provide new locks to the tenant upon arrival to the property. And the prior keys obviously need to be destroyed. Then there are stipulations as to what happens when there is a failure to maintain, smoking, whether it's allowed or not permitted, who is responsible for repairs, and who to call when there are repairs to be made. Obviously, the landlord has to provide that information. So be sure to read the repairs paragraphs. Also, who is responsible for payment. Trip charges. These are more items that pertain to security devices and exterior doors. Here's where you have the rekey the security devices within 7 days. That makes sense? Everybody clear on that? That's a recent addition to the property code, by the way. Smoke alarms, properties most provide smoke alarms in certain locations, and the property code is very clear as to where they need to be. They need to be in every bedroom and in general areas as well. Paragraph about liabilities. There's a very important paragraph about holdover, and where holdover periods will be 3 times the monthly rent calculated on a daily basis, meaning that if a tenant exceeds the number of days that they agree to be on the property, then the landlord may sue for holdover charges. And then there is a whole bunch of paragraphs on liability, casualty loss, and special provisions are typically items that has nothing to do with commissions, okay? So if there is something that needs to be addressed on the special provisions, it cannot be anything that is already in the promulgated contract. Then you have things about early termination. There are times in where a tenant may terminate the lease without penalty, okay? And here are the primary elements: military leave, family violence. Be sure you read this and understand that there are sometimes instances in where the tenant may not be prevented from departing, and no penalty will be associated with it. Even if your tenant experiences an unforeseen event, like maybe a peeping Tom in the neighborhood, in the area, that may freak the tenants out, that may be sufficient cause for the tenants to notify the landlord that such event occur. The landlord may request that the due notification to law enforcement be made in an event like that. But just keep in mind that there are situations where a tenant may bail out early and they cannot be held to the initial terms of the lease. Then there is a paragraph in where subletting of the lease may or may not be allowed. And here is paragraph 4 of paragraph 29, paragraph B, 4, and where they actually may stipulate items under which other tenants may be allowed to enter or not. Attorney's fees, representations, these are addendums that may be associated with your lease. You have lead-based paints for properties that were built before 19. Anybody? Remember? 78? Okay, very good. Inventory condition form, that should always be part of it. Parking rules, pet agreements. Protecting your home from mold, it's optional, it's not mandatory. The agreement between brokers is a very important document that you need to be aware of, and I think that I included it. This is one item that I included: broker's notice to buyers and tenants. You should complete one of these for every tenant that you bring into the relationship. And the other one is, this is very important because this has to do with who gets paid what, okay? So this is the agreement between brokers that you will receive compensation, and this is to Frank's questions as to not always is 50%, sometimes there are situations and you got a shorter term in check number 2 and what we talked about earlier as to what the proportion of rent that you will be entitled to as a representative given the number of months that you will have. And sometimes you will check B, most landlords will not allow you to do multiple years renewals because they don't want to pay for a tenant that they already have on their premises. This is a very important one because you may want to check on every instance that you represent a tenant, checkbox paragraph B 2A, because if the landlord decides to sell the property to your tenant that you bought, this is how you will be entitled to receive commissions for that transaction. So keep that one in mind. I would always want to check that one if I was you when I'm representing the tenant. As a landlord on the other side, I may feel differently, but this is a forms between agents, so this is something that is between the brokerage firms. Is that clear? Okay.
When do you send this over? With the contract or before the contract?
With the contract.
With the contract.
Yeah, with the contract. All right. So here's with the addenda of items that will be included. Notices. Here's all the agreements between the parties. This is stuff that you're probably familiar with still from real estate school. Some of these items mean something to you. I hope they do. And so here's informational items, primarily CYA types of items, basically that the brokers have no knowledge of whether a landlord is delinquent in the payment of liens and things like that. If you become aware that the landlord is delinquent, please notify your tenant. The last thing you want is to engage a landlord who may be thinking strategic default, not paying his mortgage company, and then your tenant may receive a notice of foreclosure 3 or 4 months into his tenancy or their tenancy. Okay? This is an important paragraph, and where it's kind of awkward bringing it up to your tenants, but it is extremely important. You don't ever want to talk about death on the premises, but this is something that a landlord expects. So in the most tragic event, if something happens, then the landlord is supposed to have name and address of next of kin. This usually freaks him out, by the way. Again, you have the a website reference here for your tenants to investigate if there are public predators, sex offenders, or what have you. DPS maintains a website. This is a website you may want to write down any time that question comes up. When people put you on the spot, they ask you, do you know if there are any sexual predators in the area? What should you not say? You should not say yes or no, because the reality is you may not be all knowledgeable about this. You may have known that somebody lived there, but you don't know if they're still there or not. So refer them to the website and let them do their own investigation and refer them. Now, typically a landlord, and I want to make this very clear for all of you RE/MAX, the Woodlands and Spring agents, we do not allow property management in this office from agents, okay? So don't ever get into a situation where you're going to be personally managing a property for a landlord. you are not covered by errors and omissions insurance. So anything that happens in that case will be all yours. And then the signatures pages for the tenants, the landlords, and the brokers' representatives. Okay, I've gone a little bit over 10 minutes. Could have been a lot worse. I know that I rushed through most of this. That's one of the reasons why I printed it out. I want to address, nevertheless, any questions that you may have given the enormity of information that we just came across. You can imagine the 2 hours we could have spent just on one of the forms, much less on 10 different forms. Yes?
You can provide a lead-based paint form if it's before 1978, an older property, not so much of an issue around here.
Correct, yeah, before 1978. You know, I challenge you to find one in the area. Maybe in Shenandoah, maybe in Oak Ridge North, maybe in Magnolia, Tomball, Conroe, but very few, very few. If we were in Houston, it would be highly likely, not here so much.
Do you have to also print out the pamphlet?
Yes, yeah, if you do have a property that you're dealing with that was built before 1978, do print a lead-based pamphlet for your information type. And that's a very concise PDF pamphlet.
When you're in Fusion, is there a link that goes to forms?
A list of forms,
No, when you're in Fusion, is there a link that goes to forms?
a link that goes to zip forms. Yes. Do you all have access to Back Agent? No, not yet? Okay, you will. If you just go to, right now, zipformplus.com, that will take you to